Welcome to Frank Bruno Law. I am Frank Bruno. Today I'm going to speak a little bit about supplemental needs trusts, the supplemental needs trust, and how to get money into it. In New York, does it matter whose money goes into the supplemental needs trust? It does matter. And isn't that a rule of life? It all matters. If the money in the trust is the beneficiaries from an inheritance or a court settlement or some other source, it is considered a self-settled supplemental needs trust. That's a first-party trust. From the perspective of the person establishing it, that is, it's established by the beneficiary for their own use. They are not the trustee, and the trustee is the person who manages the trust, but it is their money. A third-party trust is established by a parent, a family member, or a friend of the beneficiary, using their own money to fund it. The most important difference between a self-settled trust, first-party trust, and a third-party trust is that with a self-settled trust, any funds left in the trust after the beneficiary dies must be used to pay back Medicaid. There's no payback in a third-party trust. So, if I start a trust, a supplemental needs trust for the benefit of my grandchild, and I take $1 million and I put it into the trust for the benefit of my grandchild, that's not the grandchild's money. It was never that grandchild's money. It was my money, and I'm gifting it to the trust. Now it's in a trust. It still isn't my grandchild's money. Okay? So that's the difference between a first party and a third party trust. If you have any questions about trusts or any elder law issues, please send me an email, frank@frankbrunolaw. Thank you.